Ladies and gentlemen, welcome to another episode of PLA with myself, Nick, and Bruno. We've got two questions today. Then we'll do the first question with yourself, Bruno, and then we'll do the second one with Nick. The first question goes as follows then, Bruno. It says that we have a juristic lease signed for residential property by a natural landlord and a tenant. The tenant is a juristic person. Now, the juristic entity, the tenant now would like to cancel. Certain clauses of the lease, which speak about the early cancellation fees, read as not applicable. The tenant is cancelling their lease early by 10 months. The wrong lease has been used, the writer says. Is there any way this tenant could be held liable, Bruno, for early cancellation penalties?
All right. So when I look at the question, we just need to quickly go a step back and look at the Consumer Protection Act, because obviously this question centers around the Consumer Protection Act. So early termination or early cancellation is a principle where basically the Consumer Protection Act now allows tenants a certain right to get out of the contract earlier than they should be allowed to get out of the contract. Not to say that in the past this didn't happen, because at the end of the day, all the tenant needs to do is get up and leave. But now it's actually a right that a tenant has, and it's qualified by the fact that this does not mean that a tenant is not responsible in somehow compensating a landlord for terminating the agreement. So it's not a without fault, it's not a no consequence right that a tenant has. The Section 14 of the Consumer Protection Act is typically the provision that governs this right. The Consumer Protection Act as a whole needs to be looked at, and I think this is sometimes where a question like this might hit a barrier, where you're looking at the Consumer Protection as Section 14 that specifically says that if two juristic persons contract with each other, that Section 14, which is the section particular to fixed term agreements, does not apply. So everyone's assumption is to say, sure, but if it's not two juristic persons, that means that it does apply. And that's not necessarily the case, because remember, as a whole, the general application of the Act also excludes consumers with a threshold, and now I stand to be corrected on this figure, but the last time I checked, the threshold is 2 million rand turnover. So any juristic person that enters as a consumer into a contract with a turnover of over 2 million rand will still be excluded from the application of the Consumer Protection Act. Thus, Section 14 would never actually, you'd never get to the question of Section 14, because that would be an afterthought. So with relation to this specific matter, depending on the nature of the tenant, juristic person over 2 million, then not actually entitled to cancel the lease, and the landlord would have its normal recourse in terms of our common law and the terms of the lease agreement, etc. If it's under 2 million rand, then unfortunately, yes, the Section 14 does apply, and now one would actually have to start looking at the penalties and asking the tenant to pay a penalty. Yes, the tenant would be liable, but now you need to look at the terms of the agreement as to what it says with respect to penalties.
Thank you very much there, Bruno. Obviously dealing with the applicability of the CPA, the turnover clauses, and the Section 14(1) and bypassing. And then